Hello, everyone, and welcome to our webinar, What is an Attorney and Understanding Your Responsibilities. We have a great lineup for you today, so thank you for joining us and giving us your time. Okay, so I'd like to officially begin by acknowledging the traditional custodians of the lands across Queensland where we are all gathered today. We pay our respects to elders past, present and emerging, extend that respect to any Aboriginal and Torres Strait Islander guests online today, and honour the First Nations people we support. Hello and welcome. My name is Rachel Meehan. I'm the Senior Community Education and Engagement Officer at the Office of the Public Guardian, also known as OPG. Joining me today are some very special guests, Dr. Anne-Louise McCauley, Community Engagement and Education Leader at Caxton Community Legal Centre, and Nikki Duke, Principal Investigations Officer with OPG's Investigations Team. By the end of this session, you will gain a clearer understanding from Anne-Louise and Nikki on what is an enduring power of attorney, the attorney's role and responsibilities and limits, how to avoid some common mistakes, and where to go for extra information and help. We'll conclude today's session by answering any questions you might still have. So now I'm going to hand over to Anne-Louise to explain more about the role of the attorney in detail. Welcome, Anne-Louise, and thank you for joining us.
Thank you very much, Rachel, and thanks for this collaboration education between OPG and Caxton Community Legal Centre. In case participants don't know, very briefly, Caxton is a not-for-profit charitable community legal centre. We've been servicing Queensland for the last 50 years by providing free legal and social support services for our government-funded programs. I'm attached to the Seniors Legal and Support Service, and this education is really relevant to our clients as we often come across attorneys who are not clear about their roles, responsibilities and limitations. So let's start. All Queenslanders can plan for a future time when they're not able to make decisions for themselves, but they still want their wishes to be respected and followed by others. We call this future planning. Today we're focusing on the enduring power of attorney document, but I will briefly acknowledge other available documents. Anyone over the age of 18 who has decision-making capacity and resides in Queensland is eligible to complete enduring documents and a will. The term enduring here means that the documents can be actioned and used even when the principal no longer has capacity to make decisions. Only enduring documents, so enduring powers of attorney and the Advance Health Directive. And so they are actionable when the principal is alive and able to make decisions, unlike the general power of attorney. An enduring power of attorney allows you to appoint someone to make personal, health and financial decisions on your behalf if you lose capacity. An Advance Health Directive relates only to health decision making such as medical treatment and care, very important but not our focus today, and a will is a critical document that applies after your death. A couple of terms you'll hear me use are principal, so that means the person who creates the enduring power of attorney or the Advance Health Directive and appoints one or more attorneys to act on their behalf. Attorney, a person appointed under an enduring power of attorney to make decisions on behalf of the principal, does not have to be a lawyer, though could be. An attorney under an enduring power of attorney is often somebody personally chosen to make decisions on behalf of the principal. Someone who will know the principal's wishes and follow them, is trusted, and really follows what the principal wants, not what the attorney thinks is important. And then you've got the terms powers. So that really means that when you agree to act as someone's attorney, you take on legal duties and have legal power under the Powers of Attorney Act Queensland. We'll unpack this as we go along. Next slide, please. So who can be an attorney? The attorney's role is to manage the personal, financial and health matters depending on what the principal has authorised them to do. If you're unsure about the role after this session, You may choose to seek legal advice before undertaking the role, or else even read more about the role from the explanatory guide that is up on the Department of Justice website for attorneys. Who can be an attorney? Well, not everyone can be an attorney. There are specific criteria that make someone eligible to be an attorney. You must be an adult, so over 18 years of age, and capable of making decisions yourself. You also cannot be the principal's paid carer or have been in the last 3 years. Receiving Centrelink benefits, for example, as a family member is okay, but not working and receiving money as a carer for that person. Their doctor or health provider or someone who provides residential services to them where they live cannot be an attorney. And if you're appointed to manage financial matters, you cannot be bankrupt or taking advantage of bankruptcy laws. These rules are in place to ensure that the attorney is independent with no other conflicts of interest and able to act in line with the principal's views, wishes and preferences. Next slide. Even before you agree to be an attorney, you will want to consider the key points in these slides. And there are quite a number of them. Nikki from the Office of the Public Guardian will focus on many of them later, but I'm going to address the 2 key points that are bolded on that text, on that slide right now. Number 1, do you know how to provide appropriate support? Can you act in a supportive or supporting rather than substituting way? That is, can you do what the principal wants based on their wishes, views and preferences rather than your own personal values or what you believe is best? If you're not sure how to support decision making, there's a previous webinar in this series that you'll want to watch. But ultimately, your role is to follow the wishes and preferences of the principal. Essentially, what would mum have wanted if mum had the capacity to make this decision now? And that leads to the second essential bolded point. To follow the wishes and preferences, you need to have a conversation with the principal about what they may want. An important practice tip, but often overlooked. A document is one thing, but the actual discussion about what they may want is absolutely vital. And then we've also got the final point that is not necessarily on the slide, but is just a key practice point. Get a copy of the enduring power of attorney and read it. It can help guide your actions. The principal may have added terms and instructions to the enduring power of attorney, and these must be followed. Do you accept the rules and restrictions that the principal has set? And do you know what they are? Next slide. Some common instructions about how you may make a decision on behalf of the principal is also held within the document, which is why it's really important to focus on that. Common appointments are jointly. All attorneys must agree on every decision that is made before it's made. This means you need to make decisions unanimously with other attorneys, such as signing documents together to put a decision into action. A maximum of 4 joint attorneys can be appointed for the same matter, whether or not they be personal, health or financial. Severally, any of the attorneys can make a decision on their own without needing agreement from others. So just think about the concept and the term several or severed. By a majority, if there are more than 2 attorneys, more than half must agree before a decision can be made. And then there's opportunities for other ways that attorneys can be set up as well. And there's more on guides and the actual document guidelines itself. A key practice tip, though, is that if a principal has appointed more than one attorney, make sure that you consult with other attorneys regularly to avoid miscommunication and reduce conflict. And if there are no instructions provided, you must act jointly. Next, please. Once you sign the document, it's really important to know where the principal has stored it. There's no central registry in Queensland, so check in with the principal to ensure that you know where to find it and to access it very quickly, as sometimes decisions need to be made in that way. You will need certified copies to act on their behalf. A certified copy is a copy of the original enduring power of attorney and can be made by, the certification can be done by people such as lawyers, notary public, justice of the peace, commissioners of declaration are the common ones. And the principal may also have stored it digitally with Queensland Health by uploading via the Office of Advanced Care Planning, or it could be on their My Health record. Or even the legal firms that drafted it may have a secure storage facility. So making sure you know wherever it is stored, and also that that storage document is the most up-to-date one. Other options you may identify are mum may have put it on the kitchen fridge in a plastic sleeve. Sometimes they do that because ambulance officers may check there. But as an attorney, you will need to present that certified copy of the enduring power of attorney in various situations, and you will often be prompted by those institutions. And you can see on the slide that we have quite a number of institutions on the right there that will probably ask you directly if you want to act on behalf of somebody else. So banks, financial institutions are one of them. Real estate transactions, of course, make sense. Government agencies such as Centrelink, Australian Taxation Office, healthcare providers will ask about any enduring powers of attorney that are available and appointments in there. And aged care facilities are often requiring them now prior to somebody being admitted to aged care, and then any of the others. So good to know that you may be asked and that you have a certified copy ready to go. Next slide, please. So this slide is the perfect example of why you need to read the enduring power of attorney document. The types of decisions you can make depend on what the principal has authorised in the enduring power of attorney document. It's important to understand the scope of your authority before making decisions. In relation to personal and health decisions, you can only make decisions for the principal if they do not have capacity to make that health or personal decision required now. You can see the types of decisions outlined on the slides, but key examples around personal are where the person wants to live, what they want to eat, who they want to see, and some anything to do with medical treatment or care may also be included in the health aspects. A good tip too is to also check with the principal whether or not they've completed an advanced health directive. If you're making health decisions, as advanced health instructions may take priority. You will see that I've focused upon the decision that needs to be made now in my comments. If no decision is needed, then your role is not necessary and not actioned. If the person has capacity to make the decision themselves, no action again. If you can support the principal to make any of these decisions now, then do so rather than going directly to substitute decision making. In relation to financial matters, it can be quite different on the actual document. It may indicate that you're making decisions around financial matters immediately, or it may be that the principal specified a condition to the enduring power of attorney document. Remember, no matter what though, that before actually using and actioning any behaviours or requirements of the enduring power of attorney, you must have signed the attorney's acceptance in section 5 to begin acting. And you should notify relevant parties when the enduring power of attorney is activated and if decisions are needed whilst the principal lacks capacity. Next slide, please. As an attorney, you'll need to consider whether and when the principal needs more assistance with either personal, health or financial. This slide has quite a lot of information on there that if you want to do a deeper dive into how you may assess capacity, I refer you to the capacity assessment guidelines on the DOJ website, Department of Justice website. However, some key practice tips for now. Capacity for decision making is defined by legislation, and so is a legal term, not a medical one. It's based in the legislation, the Guardianship and Administration Act is one example. Health professionals such as doctors or psychologists can provide helpful insights, but their opinions have limitations. Everyone is presumed to have capacity to make decisions unless proven otherwise. Capacity depends on context and support and the type of decision that's needed now. The principal deemed to lack capacity for health decisions may still retain ability for personal and health decisions, for example. And capacity may fluctuate and may be regained. An acute episode of mental illness may resolve and the attorney can stand down. When thinking about capacity from a legal perspective, it's around considering their understanding of the decision, whether or not they're making the decision freely and voluntarily, and can they communicate the decision in some way. Just you disagreeing with their decision doesn't mean that they lack capacity either. And a diagnosis like dementia or psychosis doesn't automatically mean a person lacks capacity. So support using plain language and visual aids can also help principals make decisions sometimes. Next slide, please. And finally, I think from my perspective, there are situations where your powers may be automatically revoked or cancelled if you're acting as an attorney, or the enduring power of attorney itself is no longer valid. You can see here quite a number of examples, and some of them we've already addressed, for example, on the right. However, the ones that commonly get people confused is probably around the actions of the principal when a new document is created. So if a new document's created and you are no longer appointed as the attorney, then you need to stand down. If the principal dies, then the enduring power of attorney role dies with the person. And then there are other examples around marriage, civil partnership. The court or the tribunal may cancel the enduring power of attorney, and we've already spoken around about regaining decision-making capacity. The other thing, I suppose, is around the actions of attorneys, and this gets confused, is if the attorney dies, that would make sense that their activity dies with them. However, with resignations, you must give notice to the principal if you wish to resign, but at the same time, you must have capacity to do so. And if the principal no longer has capacity to accept that resignation, then you have to apply to QCAT. Otherwise, I think they're the most important things, and you can read about the rest and keep these as a note de memoire as well for you into the future. Hand back to Rachel.
Thank you, Anne-Louise, for that wealth of information on the role of the attorney. Speaking from personal experience, I'm an attorney for a loved one who does have dementia, and yes, it does create a bit of extra work at times, but knowing that I'm enabling and empowering them to be still involved in decisions that impacts on their lives is really fulfilling and rewarding. So thanks, Anne-Louise. It's really informative. All right, so now we're going to talk about what you can and can't do as an attorney and some ways to avoid common mistakes. So we're going to hand over to Nikki Duke now from the Investigations Unit at OPG. Welcome, Nikki.
Thank you. Hi, so I'm Nikki Duke and I work in the investigations team at the Office of the Public Guardian, where we look into concerns relating to decision making for vulnerable adults who lack capacity. So it's important that you understand your obligations and responsibilities as an attorney, but also to be clear on what you're not permitted to do. Obligations or legal duties are mandatory legal requirements under the Guardianship and Administration Act 2000 and the Powers of Attorney Act 1998. Responsibilities, or your tasks and actions, are the specific practical actions an attorney performs to carry out their duties, such as paying bills, lodging tax returns, selling a house, or choosing a nursing home. Essentially, obligations are legal how, so acting honestly and avoiding conflicts, while responsibilities are the functional what, so managing bank accounts and making health choices. The enduring power of attorney explanatory guide includes an attorney's obligations and responsibilities in detail. As an attorney, you must follow specific legal requirements. These include applying the general principles and healthcare principles if those apply, acting honestly and diligently, consulting with the principal's other attorneys, protecting the principal's confidential information, and following the rules for gifts and donations, conflict transactions, supporting the principal's dependents, investments, keeping records, and keeping property separate. However, there are limits to your powers as an attorney. You can't make decisions the principal hasn't authorised in the EPOA. You can't make decisions outside of the terms and instructions of the document, nor can you use the principal's money or property for your own benefit. You can't make or change the principal's will, or vote on behalf of the principal. You can't make decisions about the principal's children or the other dependents, or act in ways that are illegal or unethical. Not consider the principal's views, wishes and preferences unless it's impossible to act on them, or doing so would cause harm. For example, wanting to remain at home when it isn't a safe environment. You can't make decisions after the principal has died. Your authority ends at that point. Or delegate your responsibilities to someone else. If you're unsure about your role or responsibilities, you should check the EPOA document or seek independent legal advice. Next slide, please. So let's look at some common mistakes that attorneys make. So mixing funds. Attorneys mix in their own money with the principal's in a single bank account. This includes using the principal's money to reimburse themselves without proper justification and failing to maintain accurate records. An example is an attorney who chose to stop working to care for the principal and then began paying themselves from the principal's funds to replace their income. While the intention may have been to support the caring role, this isn't acceptable, as attorneys must not financially benefit from their position. Conflict transactions and misuse of assets, so attorneys engaging in gifting money or selling the principal's property to themselves below market value. Misuse of the principal's assets, such as their car, is also a recurring issue. An example of a conflict transaction would be where a principal has historically paid for a grandchild's private education. If the EPOA permits conflict transactions, it may be reasonable for those payments to continue. However, a QCAT application should still be made to ensure transparency and proper authority. In contrast, using the principal's funds for personal expenses, such as attorney paying for their own Netflix subscription, is not appropriate and would be a misuse of funds. Misunderstanding capacity and powers. Attorneys lacking understanding of capacity, including where their powers begin and end, or not following instructions. Attorneys failing to adhere to the principal's instructions as outlined in the EPOA document. They sometimes fail to consider the principal's views and wishes. Lack of awareness of responsibilities. So attorneys being unaware of their broader responsibilities, such as managing NDIS funding on behalf of the principal. Not keeping receipts and records. So keeping receipts and records provides accountability and accuracy in dealings and transactions. An example of where record keeping can fall short involve regular ATM withdrawals and online transactions from a principal's account, despite the principal not having the ability to access them themselves. While the attorney appeared to be acting with good intent and explained the funds were used for the principal's day-to-day needs, they were unable to provide receipts or records to support this. Attorneys are required to keep clear and accurate records so they can demonstrate that all spending is in the principal's best interests. Without this, it can create uncertainty and a lack of transparency, even where the intentions are genuine. Dispute resolution and decision making. Finding out how to resolve disputes regarding an attorney's decisions, how attorneys should make decisions, and how they should communicate these decisions to the principal's friends and family. Or not seeking support for when needed, such as for medical decisions. Another common challenge is not seeking the right level of support. Often this comes from a place of love and commitment. For example, wanting to honour a promise to care for someone at home. However, without exploring available options such as respite care or in-home support, attorneys can become overwhelmed, particularly as their own health begins to decline. This can unintentionally impact both their well-being and the quality of care provided. Accessing the right supports and ensuring appropriate services and funding are in place helps create a more sustainable and positive outcome for everyone involved. Next slide, please. So what happens if you don't follow the rules? An attorney has important legal duties and obligations that they must comply with, and the rules about certain financial matters are especially complicated. It's strongly recommended that both the principal and attorney get independent legal and financial advice before being appointed and acting on complex financial decisions. There are consequences if you fail to comply with your duties as an attorney. You could be removed as an attorney, so QCAT can remove you if you don't meet your obligations, or face criminal liability. It can be considered a criminal offence to act dishonestly or without reasonable care. Need to pay compensation. QCAT or the Supreme Court can order you to compensate the principal or their estate for any losses caused by your actions. Need to account for profits. You may be required to return any profits gained from failing to meet your obligations. Or have your powers suspended. OPG, through our investigations process, has legal authority to suspend powers in specific circumstances. OPG will then formally advise QCAT to review it and make a final determination. Need to produce records and documentation. QCAT or the Supreme Court can make additional orders, such as requiring you to produce records or audited accounts. Many attorneys don't realise the level of responsibility involved until they're in the role. Reaching out for guidance or support early can make a significant difference. QCAT and the OPG both provide useful educational material on their websites where many common questions are answered. Next slide, please. Now to wrap up, here's some practical tips for being an attorney. To be an effective attorney, it's important to understand the terms of the EPOA document and your responsibilities. Where possible, use supported decision making to involve the principal in decisions and follow good practices to ensure their wishes are honoured. If you're unsure about your role and responsibilities, seek legal advice to ensure you're meeting your obligations. By doing so, you can safeguard their money and property, prioritise their well-being and uphold their rights. Communicate early to understand the principal's wishes. Talk to the principal about their wishes and preferences before they lose decision-making capacity. Stay organised. Keep the EPOA document, the principal's financial records and other important papers in a secure and easily accessible place. Use a method that works for you. That could be a diary or spreadsheet to track decisions and transactions. Be transparent. Share information with the principal if possible. Other attorneys, if there are multiple, and the nominated person, if there is one. And seek help if needed. For complex decisions, consult a lawyer, financial advisor, or healthcare professional. Professional advice ensures that you've taken the right steps to make an informed decision. The cost of this advice is generally a legitimate expense payable from the principal's funds. And know your limits. If you feel you can't fulfil your role, let the principal or other attorneys, nominated person, or a relevant authority know. Take time to reflect and review the document after you agree to be an attorney and sign the document. Set a reminder to review the document and attorney resources on an annual basis. Reflect on how well the arrangements are working and make changes if necessary through the right avenues, such as QCAT or the Supreme Court. Most issues we see aren't intentional. They often come from a lack of understanding. There's lots of support and guidance to assist you in your role. I'm now going to hand back to Rachel.
So I just want to reiterate here that there are many organisations where you can go for support and more information. This is just some of them. I think the main thing to highlight on this slide is that to access the enduring documents and the explanatory guides and other information that we've referred to today, visit the Queensland Government Publications site, and we'll include the link in the post-webinar email for you. If you'd like to hear more webinars such as this from OPG and stay up to date on our news and upcoming events, please subscribe, follow us on LinkedIn and YouTube as well. We'll be putting all the recordings of our webinars, and we've got some videos and recorded presentations on YouTube, so make sure you get there and have a look. And lastly, thank you so much to all of you for joining and engaging with us today. We do hope you found this information session valuable and informative. We've got a link currently on the slide there that takes you to a feedback survey. We would very much like to hear from you. which will help us with future education sessions. And lastly, but certainly not least, I'd like to extend a very special thank you to our guests, Dr. Anne-Louise Macaulay from Caxton. It's been an absolute joy working with you, Anne-Louise, and collaborating with you on this webinar. And thank you also to Nikki Duke from our investigations team for sharing, both of you for sharing your knowledge and your experiences with us today. So that will be it for us today. Thank you very much again for your time, and we wish you a very lovely afternoon.